Welcome to the new manager in labor law training, where you're going to learn about employment labor laws, how it shows up in the workplace, and the HR internal controls for compliance. So today we will discuss your essential role and compliance as a manager who can hire, train, promote, and even discharge a team member. So, what is the objective? Well, we need you to learn what the organization's expectations are for the manager pursuant to the topics and how to protect the company. You need to have some basic understanding of the employment laws that could impact the employee personally and what human resources expects the manager to do and know with regard to these employment laws. So we need for you to know your role as it relates to employment law and ensure the employee have equal opportunity to reach their full potential in the workplace. Beginning with the employment labor laws. In California, we have governing agencies that execute and enforce those regulations. So let's review who they are. So the California Civil Rights Department, formerly the Department of Fair Employment and Housing, is the state agency charged with enforcing California civil rights laws in California. We have the Equal Employment Opportunity Commission, also known as the EEOC, who enforces federal disability discrimination laws, and the California State's Division of Labor Standards Enforcement. It is also known as the California Labor Commissioner's Office. It handles claims under the California wage and hour laws, as well as whistleblower retaliation. Those agencies that mainly manage all of the California employment labor laws. Let's start with what are some of those laws? What are some of those acts? We're going to start with the California's Fair Employment and Housing Act, which is an act that prohibits discrimination, harassment, or retaliation based on statutorily protected characteristics against an employee, an applicant, an unpaid intern, or volunteer, or a contractor. So it is illegal for an employer to take negative action or retaliate against a person because they complained about discrimination, whether formally or informally, filed a discharge of discrimination with an agency, or participated as a witness in an employment discrimination investigation or lawsuit. So the act prohibits these discriminatory acts towards protected categories. So who are they? Well, in California law protects individuals from illegal discrimination by employers based on the following. So in addition to the federal law, we have race, color, marital status, military, veteran status, ancestry, national origin, religion, creed, age 40 and over, disability, mental and physical, medical conditions, genetic information, sex, gender, sexual orientation, gender identity, gender expression, disability, mental, and physical. So those are your protected categories. The Act also calls for a reasonable accommodation. So the California Fair Employment and Housing Act requires employers to provide reasonable accommodation for individuals with a physical or mental disability to apply for jobs and to perform for the essential functions of their jobs unless it would cause an undue hardship. So reasonable accommodation can include, but it's not limited to, changing job titles, changing work schedules, relocating work areas, providing mechanical, or electrical aids, or providing leave for medical care. And you, as the manager, get to manage these types of accommodations. The Act also requires what they call an interactive process, because if you're going to be providing a reasonable accommodation, the law requires that you start it. So the employers must initiate an interactive process with an applicant or employee requests, or when an employee requests reasonable accommodation. We must also offer to initiate an interactive process when the employer becomes aware of the possible need for an accommodation. So if you become aware that someone is dealing with a medical condition and you become aware that it's impacting their jobs, this is when you might want to start the communication. So in California, it is unlawful for an employer to fail to engage in a timely, good faith, interactive process. Okay, so you as a manager are responsible for that. The point of the process is to remove barriers that keep people from performing their jobs that they could do with some form of accommodation. So really the process requires an individualized assessment of both the job and the individual's specific physical or mental limitations that are directly related for the need for reasonable accommodation. And it could be as simple as allowing them to work a shorter schedule if they're dealing with a new medication. There's plenty of ways that we can help on the interactive process. And at the end of this presentation, we'll discuss about some of those ways, more about those ways. We also have what they call the Americans Disability Act, also known as ADA. So Title I of the Act prohibits private employers, state and local governments, employment agencies, and labor unions from discriminating against qualified individuals with disabilities in the job application process. And it could also include hiring, firing, advancement, compensation, job training, and other terms and conditions and privileges of employment. So Title I also covers your medical examinations, medical records, drug and alcohol abuse, and retaliation for opposing any of those practices. So as you can see, it does cover a lot. So the Act does indicate you got to be qualified. So what is a qualified individual? Well, it's a person who has a physical or mental impairment that substantially limits one or more major life activities, has a record of such an impairment, or is regarded as having such an impairment. That's how the ADA got started, but then in 2009, it was extended, and now we have an amendment to the Act. So, the ADA defines a disability in part as a physical or mental impairment that substantially limits a major life activity of an individual. Okay, which is the first prong of defense. We just read it. But the amendment made significant changes to the definition of disability, making it easier for an individual seeking protection under the ADA to establish that they have a disability as defined within the law. So by extending the terms of the ADA, the extension provides greater protection under the law. So the findings and purposes make clear that Congress intended to apply a less demanding standard than applied by the courts. And in fact, the Act was to cover a broad range of individuals. So similar to FEHA, a qualified individual, they have the same qualifications. And that if they have a disability, this Act requires you, like FEHA, to accommodate. So reasonable accommodations are adjustments or modifications provided by us to enable employees with disabilities to enjoy equal employment opportunities. Okay? So the interactive process is owned by the manager and the employee. That's how HR sees it, because you have the best ideas. You, supervisor, manager, and the employee know exactly the accommodations needed. HR is here to help you create that process and be successful in it. So some of the ways you can help this individual is making existing facilities used by employees readily accessible to and usable by persons with disabilities, job restructuring, modifying work schedules, reassignment to a vacant position, acquiring or modifying equipment or devices, or adjusting or modifying examinations, training materials, or policies. So HR does have some ownership in this. So let's look at the FMLA, CFRA. Our laws have what we call a California Family Rights Act. That's a CFRA. It is very similar to FMLA, except it has greater benefits. So the law allows us to go with the greater benefits. But we have to deal with both FMLA and CFRA in California, where the laws differentiate. Okay, that's more about, you can learn more about that in the actual written policy. For now, we're going to cover what it is. CFR provides eligible employees with up to 12 weeks of unpaid job protected leave to care for their own serious health condition or a family member with a serious health condition, or to bond with a new child. Okay. In addition, California law requires covered employers to provide employees disabled by pregnancy, childbirth, or a related medical condition with unpaid job protected leave, known as the PDL. Okay. Or accommodations must follow. So CFRA covers these family members in California. We have our spouse, our domestic partner, our parent-in-law, our adult child, our child of a domestic partner, grandparents, grandchildren, siblings, and just recently in year 2023, someone else related by blood or in a family-like relationship, what they would call a designated person. So on file, your employee can take care of someone that isn't a family member. So what is pregnancy disability leave? Well, it's what is PDL? While an employee disabled by pregnancy, childbirth, or related medical condition is entitled up to 4 months of disability leave per pregnancy. Leave can be taken before and after during any period of time the employee is physically unable to work because of pregnancy or pregnancy-related conditions, okay? PDL is available for a time off needed for prenatal or postnatal care, severe morning sickness, doctor-ordered bed rest, childbirth, recovery from childbirth, loss or end of pregnancy, or any other related medical conditions. State sick and bereavement. Yes, the state of California has what we call a paid sick leave, which requires employers to provide at least 24 hours or 3 days off each year. This includes full-time, part-time, and temporary workers. So when do these benefits come into play? Well, the law says for anyone who works for the same employer for at least 30 days within a year in California, and complete a 90-day employment period before taking any paid sick leave. So basically, any employee that works for you longer than 30 days in any capacity is allowed after 90 days to have this access to these hours. So the paid sick leave can be used to recover from physical, mental illnesses or injury, to seek medical diagnosis, treatment, or preventative care, or to care for a family member who is ill. Employees also have access to what we call a kin care. So kin care is time provided to employees to take time off work to care for a family member. This allows employees to use up to half of their sick leave for specific family members as defined by California law, which is going to be very similar to the same group of family members for CFRA and the paid family leave. So reasons for the leave, it's a little bit different. Reasons for leave can be to seek diagnosis, care, or treatment for an existing health condition of an employee's family member, to support a family member who was the victim of domestic violence, or to support a family member who was the victims of sexual assault, or to support a family member who was the victims of stalking. The law does not allow us to interfere with any of these leaves. So your role is to be able to know when your employee would need some time off. And now these are some of the parameters that they can take time off. So you should be familiar with some of the reasons for time off, so you could grant it accordingly. Okay? The law just in 2023 added bereavement leave. So private employers with 5 or more employees are required to grant an eligible employee up to 5 days of bereavement leave. To be eligible, an employee must have been employed for at least 30 days before taking the leave. So that's a minimum of 30 days. And they can take that leave for a spouse, child, parent, sibling, grandparent, grandchild, or parent-in-law. Our policy actually covers more, and we do pay bereavement leave in our policies up to 5 days. Now, we also have what we call paid family leave. So paid family leave provides benefit payments to people who need to take time off work to care for a seriously ill family member, to bond with a new child, to participate in a qualifying event because of a family member's military deployment. Those are the reasons. If eligible, the employee can receive benefit payments for up to 8 weeks. Payments are about from 60 to 70% of your weekly wages earned. There is no waiting period. So this is a benefit that all employees pay into, that is managed by the state disability. So just that you know, the leave provides benefit payments, not job protected. It is, if you're going to get job protection, you're going to get it from the FMLA. So this is a benefit that is managed by the state disability that many of our employees participate in, especially during the baby bonding. It's a great benefit for you to be aware of, to offer your new parents. So sexual harassment. Sexual harassment is a form of discrimination based on sex, gender, including pregnancy, childbirth, breastfeeding, or related medical conditions, gender identity, gender expression, or sexual orientation. It may include unwelcome sex-based conduct, such as unwelcome or unsolicited sexual advances, offering employment benefits in exchange for sexual favors, conversations regarding sexual activities, leering, gestures, or displaying sexually suggestive objects. So sexually harassing conduct need not be of a sexual nature or be motivated by sexual desire. It may include situations that begin as reciprocal relationships, but that later cease to be reciprocal. So sexual harassment is generally categorized in two types. You have your quid pro quo, the Latin this for that, or sexual harassment is when someone conditions a job or promotion or any other work benefit on your submission to sexual advances or other conduct based on sex. Okay. Hostile work environment. Sexual harassment occurs when unwelcome comments or conduct based on sex unreasonably interferes with your work performance or creates an intimidating, hostile, or offensive work environment. So you may experience sexual harassment even if the offensive conduct was not aimed directly at you. So as you know, as a new employee, we are required by the state to give you a brochure all about sexual harassment, and you as a manager are obligated to attend training within your first 6 months of your promotion or being hired at our company. And it's a 2-hour training that you are required to recertify every 2 years. So this presentation here is just to remind you of the law. We talked a little bit about those discriminatory laws, but we also have the equal opportunity laws, which California has a few laws, more laws. They call it the California Equal Pay Act. Fairly new law. The California Equal Pay Act, also known as CEPA, forbids public and private employers from paying you less than what they would pay employees of the opposite sex, a different race, or a different ethnicity for substantially similar work. So substantially similar work, there is a definition that it's work that is mostly the same with regard to the following 3 factors: skill, education, training, experience, and ability. Your effort, that necessary physical and mental labor. Responsibility, that required accountability and duties when performed under similar working conditions. The act also has what they call protected activities, including retaliation if they have done any of the following. So specifically, CEPA prohibits the employer from taking adverse action against employee for either bringing a wage claim, revealing what they've earned to another employee, or asking a coworker about what they earned, or talking about a coworker's wages. These are protected acts in the state of California. So what does retaliation look like if it shows up? Well, the state would say if it shows up in the form of demotions, suspensions, terminations, reduction in hours, and or reduction of wage rates. The Fair Labor Standards Act and fair wages. So California FLSA. The California Fair Labor Standards Act is a set of state laws that sets the rules for minimum wage, overtime pay, record keeping, and youth employment standards affecting employees in private sector, federal, state, and local law governments. Okay, so California FLSA also prohibits employers from discriminating, another law, discriminating against workers based on their age, disability, race, color, religion, sex, or national origin. So under the Fair Labor Standards Act, all employees must be classified as either exempt or non-exempt from minimum wage and overtime provisions. So one of the key aspects of the Fair Labor Standards Act is its provision for overtime pay. However, not all employers are eligible for overtime pay due to various exemptions outlined in the law. Okay, so the single most common and costly mistake made by employers is the misclassification of employees as being exempt from overtime provisions. So what does that mean to a manager who wants to promote? Well, the standards regulate that the roles must meet a salary and a duties test to be considered exempt. You as the manager should be aware that it's not that simple in California. So one, they must earn a minimum monthly salary of no less than 2 times the state minimum wage for full-time employment. And deductions from an exempt employee's salary on a weekly are very limited. So they want to ensure that this person is exempt. Second, to be considered an exempt employee, a person must spend 50% of their time performing exempt job duties. So your role is to understand that you have an exempt, some of you manage employees who are exempt. Well, they should be spending 50% of their duties high-level work, making decisions. You do not want to start changing an exempt individual's job duties or descriptions, or even cutting their pay out without talking to HR. Otherwise, if you conduct acts that you try to treat someone like an hourly employee, the law will then want you to classify them as an hourly employee for that particular time that you're having them work like a non-exempt employee. You need to partner closely with HR if you're going to be deviating from any of your exempt employees' duties. We've also included in this presentation the National Labor Relations Act. National Labor Relations Act. We are not a union employer. However, you should be aware of this act and what some of the provisions look like. So in 1935, Congress passed the National Labor Relations Act, also known as the NLRA, making clear that it is the policy of the United States to encourage collective bargaining by protecting workers' full freedom of association. The Act protects workplace democracy by providing employees at private sector workplaces the fundamental rights to seek better working conditions and designation of representation without fear or retaliation. The Act also includes, among many things, one of them is the protected concerted activity. So the law gives employees the right to act together to try to improve their pay and working conditions, with or without a union. If employees are fired, suspended, or otherwise penalized for taking part in protected group activity, the National Labor Relations Board will fight to restore what was unlawfully taken away. So what it's basically saying is your employees have a right to get together and just talk. And if they want to talk about ways to create better benefits, you don't want to stop them. The ADA Act. So that's our Age Discrimination Act. So age discrimination involves treating an applicant or employee less favorably because of his or her age. So the Age Discrimination in Employment Act forbids age discrimination against people who are age 40 or older. So the act includes age discrimination and harassment. It is unlawful to harass a person because of their age. It is also, the act includes age discrimination and employment policies. An employment policy or practice that applies to everyone, regardless of age, can be illegal if it has a negative impact on applicants or employees over the age of 40. So we created this presentation to share with you, not to quiz you on how well you understand all the laws, but to let you know that these laws exist. And we need you as the manager to make sure they don't show up in the workplaces. So we need to make sure that it doesn't show up in the workplace. So how does it show up in a workplace? Well, discrimination comes in many forms. So though discrimination comes in many forms in the workplace, it refers to the act of treating someone differently because of their protected category. Okay, so with respect to one of the following, treating them, their compensation, job assignments, work conditions, and the terms and privileges of their employment. So it's important to note that discrimination can occur at any stage of employment and not just during. So it's illegal at all stages. What are some of the phases? Well, it can show up during the recruitment period. If recruiting materials specify an age or claim that the company wants to foster a youthful environment, it can show up during the hiring process, when considering promotions, when making decisions regarding raises, determinations regarding layoffs or firing people, when you're setting retirement requirements, when considering training opportunities or setting age limits for who can be trained, when creating apprentice programs, and when determining employee benefits. It can also show up in what we call a leave interference. We talked about FMLA and CIFRA. So this act prohibits interference with an employee's right to take a leave. Same thing with paid sick time and kin care. Okay? So, and interfering with the exercise of an employee's right would include, for example, not only refusing to authorize FML leave, but discouraging an employee from using such leave. It would also include manipulation by a covered employer to avoid responsibilities under FMLA. For example, changing the essential functions of the job in order to preclude taking a leave, or reducing hours available to work in order to avoid employee eligibility. There's a lot of protection about interference. Basically, you don't want to interfere. So same thing with paid sick time. So what the law is saying is an employer shall not deny an employee the right to use accrued sick days, discharge, threaten to discharge, demote, suspend, or in any manner discriminate against an employee for using accrued sick days. This means that if an employee has accrued sick days available, an employer may not deny the employee the right to use those accrued paid sick days, including the right to use paid sick leave for a partial day, and may not discipline the employee for doing so. So we have the leave interference. Another way it shows up is retaliation in the workplace. Retaliation is defined as any adverse employment action taken against an applicant or employee because that person engaged in activity protected under this policy or reasonably thought to be protected under this policy. Protected activities may include but are not limited to reporting or assisting a suspected violation, or cooperating investigations or proceeding arising out of a violation. Examples of retaliation include, but not limited to, demotion, suspension, reduction in pay, denial of a merit increase, failure to hire or consider for hire, refusing to promote or consider for promotion, harassing an employee for filing a complaint or denying promotion because they filed a complaint, denying accommodation or not talking to the employee when required by job duties, or excluding the employee from job-related activities because of filing a complaint. We see that it shows up in the workplace. We see that there's plenty of employment labor laws to be aware of. So what's your responsibility? Well, we want you to have a compliance partnership, and that would be human resources. Okay? So what we've done, we've created comprehensive anti-discrimination policies that outline the company's commitment to equal employment opportunities, and they provide clear guidance for addressing and resolving complaints. So what are those HR internal controls? Well, they are your policies. They are our policies and your policies. Ours, we created them, and you are going to help us enforce and ensure that they are applied equally and to all people. So we have our ADA policy, our accommodations, anti-discrimination, anti-harassment, California Equal Pay Program, our California Paid Sick Leave policy on how to use it, when to use it. And then we have a whole section in our handbook that goes into policies with regards to leaves. We also have our HR resources, okay? We are an affirmative action employer, so we have our EEO policy. And our employee handbook are all the required leaves. We have our performance development program to help you get the very performance development program to get the very best, to help you succeed in those programs. We have a compensation policy with annual audits for compliance. We have a transfer and promotion guidelines, as we want to ensure that you are making sure that everyone's getting the best opportunity. We have our training and compliance. California Anti-Harassment Supervisory Training is our 2-hour training. All new managers go through it within the first 6 months, and then every 2 years after. And all of our employees within 6 months get 1 hour mandatory training. And our affirmative action program training, which includes our targeted goals. And for a full list of compliance, you need to go to our HR page. We do even have what we call equity controls. Okay, our organization forwards an annual data on the pay, job category, race, ethnicity, and gender of California employees to the California Civil Rights Agency. So we are required by law. So this ordinance was created to encourage employers' self-assessment of pay disparities in the workplace and to promote voluntary compliance with equal pay and anti-discrimination laws. So we use this data to conduct our own internal pay audits to identify and close those gaps. Yes, we do identify in these audits. We also have what we call direct communication. So if anyone wants to complain, there are other complaint mechanisms. They can complain to any manager in the organization for any discriminatory, harassment, or retaliation violations. To any manager in the organization, we have an anonymous employee hotline that every new and hire receives, a little keychain on that. Or we have our designated HR representative. And then lastly, they do have a right to go to a third-party representative, including someone in the EEOC or California Rights Department. The complaint process. We have a written complaint process um, that we work on. Employee does not have to complain to their supervisor. We expect you, by the way, as the manager, if you see anything, as you know, that's what you sign off to. You are required by our organization to report any acts, okay? But this is what the process could look like. And complaints can include both oral and written communication. It will include a timely response. It will include an impartial and timely investigation by a qualified investigator. We use our senior HR reps or we hire an outside person. We will appropriate options for remedial actions and resolutions. They will be appropriate to each situation. There will be no retaliation of any kind, and we will be monitoring for a year after the incident to ensure there's nothing that follows post the complaint. So the complaint will be kept confidential to the extent that is possible. If you don't know this, in California, all employees must meet workplace posting obligations. So the Department of Industrial Relations has a huge list of all the postings that we are required to post. The Civil Rights has required posters. All of our posters will be in areas where we'll be in the lunch area, and in addition to the areas where employees clock in when they first arrive. Our operations team, there's all these posters are out there for view. Well, now you know, in order to manage and enforce all these labor laws is a huge responsibility. And we need to approach it as a team. Like in any huge responsibility, you want to approach things as a team and have those team members, LinkedIn team members, with that appropriate skill set to help you succeed and not getting any complaints. So we are your partnership. We have internal controls. We have direct communication channels that we want you to be aware of and for you to partner with us, okay? So your role as a manager includes ensuring your employees have equal opportunity in all aspects of employment. That is the expectation of our organization and the expectation of your executive team, who, by the way, allowed us to present this and who reviewed and approved the content here. So we want you to learn the HR internal controls and practice them daily. Lastly, partner with HR for continued learning to be the very best people manager. Okay, so thank you for attending and learning how to promote and grow your team through compliance. We hope you guys have a great day. Exiting with the references. Thank you for your time.